Today, we're diving into a critical topic. Can homeopathic practitioners prescribe allopathic medicines in India? Spoiler alert, it's a legal minefield, so stick around for a detailed analysis. First things first, under India's legal framework, the practice of prescribing medicines across systems, known as cross-pathy, is prima facie prohibited. The statutory frameworks, regulatory authorities, and even court judgments make it clear. Homeopathic practitioners must stick to homeopathy. Let's start with the key legal provisions. The Homeopathy Central Council Act, 1973 defines medicine strictly as those recognized under homeopathy and restricts practice to homeopathic principles. It's backed by the Drugs and Cosmetics Act, 1940, which specifically regulates prescription drugs under Schedule H and H1. These schedules explicitly allow only registered allopathic doctors to prescribe such medicines. Now let's look at how courts have interpreted this issue. In the case of Dr. Mukhtiar Chand versus State of Punjab, 1988, the Supreme Court firmly held that practitioners of one medical system cannot prescribe medicines of another system unless explicitly permitted by state law. Also, in the case of the Kerala High Court in Kerala State Pharmacy Council versus Dr. Jacob Matthew 2007, reinforced this, stating that homeopaths prescribing allopathic medicines even in emergencies is not allowed. State laws add another layer of clarity. For example, in Maharashtra, the Maharashtra Medical Practitioners Act 1961 explicitly prohibits cross-system prescription and imposes penalties for violations. Similarly, Karnataka's regulations under the Ayush department mandate strict system-specific practice. It's not just the law. Professional ethics also play a role. The Central Council of Homeopathy enforces a strict code of ethics, requiring practitioners to adhere to homeopathic principles. Violating this can result in disciplinary action. Similarly, the Medical Council of India, now the National Medical Commission, is firmly against cross-pathy. Are there any exceptions? Well, not really. Emergency care provisions under common law may allow basic first aid, but there's no legal protection for cross-system prescription. Some states permit limited integrated practice, but only with additional qualifications and legislative authorization. Cross-system prescription isn't just unethical, it's illegal. Violators face criminal liability, imprisonment up to 1 year under the Drugs and Cosmetics Act, civil liability, suspension of licenses, lawsuits for professional negligence, and consumer protection penalties. Recent reforms like the National Medical Commission Act, 2019, emphasize system-specific practice. Meanwhile, the Ayush Ministry is working to strengthen the identity of traditional systems like homeopathy, Ayurveda, and Unani, discouraging cross-system practices. So what's the bottom line? Homeopathic practitioners prescribing allopathic medicines is a big no under Indian law. Violating this attracts severe legal consequences. If you're a medical professional, understanding these boundaries is crucial, not just for compliance, but also for patient safety. Don't forget to like, share, and subscribe for more medico-legal insights.